Welcome to the Torts Micro Review. In this seminar, we'll go over all of the major testable issues from this very important subject. And as we do so, I think you'll begin to get a very clear idea about how to organize your thinking, and not just for this subject. Torts is an excellent subject to begin a review for a bar examination. And that's because this subject serves as a very neat and tidy model for the way that we will approach all of the various subjects. Torts is what we call a civil remedies subject, because we've got litigants in civil court trying to obtain or defend remedies. And in every problem from torts and contracts and real property and many or most problems from business organizations and even many wills and trusts problems, you'll see a civil litigant in court. Always a civil litigant is going to need one or more theories of liability. The defendant likely will have defenses to those theories of liability. Also, a plaintiff coming to civil court will have one or more prayers for relief, remedies. So torts is a model subject for considering civil litigation. A plaintiff in a torts problem will always have one or more theories of liability. Each one of these theories breaks down into elements. So our job is to identify what is important and to know it well enough so that we can compartmentalize our analysis into the various elements of the theories of liability. And this is not merely an academic exercise. This is a practical exercise, because in court, this is how all of us litigate. The plaintiff has to have one or more theories of liability and one or more prayers for relief. The defense is almost certainly going to have defenses either to the theory of liability or to the prayer of relief, and often to both. On a bar examination, or for that matter an examination in law school, typically what you are expected to do is either be able to identify the various theories of liability or be able to distinguish between the various theories of liability. Other problems will focus your attention on remedies, and remedies breaks down into three fairly neat categories: damages, restitution, and equitable relief. The videos in this micro review seminar are going to track fairly closely to the National Conference of Bar Examiners outlines. We're not going to reinvent the wheel here. We're going to understand how the wheel that exists already is engineered. So the various videos in this seminar are going to track the National Conference of Bar Examiners outlines. Also, I encourage you to annotate the outlines that I have provided. You get them both in a PDF format and in an editable format. And the idea is not to create a gigantic textbook-size outline. The idea is to identify areas in which you have made substantive errors and then plug those errors into an outline. That will help you learn the material. Actually, typing up the new information will help put it into your brain. But also, you'll have the ability to figure out whether or not one legal point or another is very important. It's easy to get lost in minutia, and the whole point of this series of videos is to give you the big picture and enough of the fine points that you can have a fairly clear idea about what to study. Your study should be fueled by your practice. You should do as little upfront study as you can get away with. Then get into practice and see where your strengths and weaknesses are. Then study your weaknesses. So the way to think about a torts problem in the abstract or for essay purposes is to identify how the plaintiff has been injured and be as comprehensive as possible. Think like a plaintiff's lawyer. Every possible injury should be mentioned and it should be redressed. Then think about the theories of liability. Once we've got injuries, we connect them to theories of liability, each of which breaks down into elements. Then we consider the defendant's defenses to the theories of liability. And we will discuss each of the defenses as we go through the various theories of liability. Then we consider all of the plaintiff's prayers for relief. And again, think like a plaintiff's lawyer. Every possible prayer for relief is something we're going to ask for. then on the defense side, we will be as meticulous as possible about attacking the various prayers for relief, arguing instead that the plaintiff is entitled to either nothing or to the bare minimum. Now, as we consider the various theories of liability, this series of videos will directly follow those of the outline of the National Conference of Bar Examiners. So we begin with intentional torts and defenses to intentional torts. Keep in mind that this is a fairly finite body of knowledge. Intentional torts breaks down into two categories: intentional torts to the person and intentional torts to property. The intentional torts to persons include assault, battery, and false imprisonment. And the intentional torts to property include trespass and conversion. That's it, a fairly simple laundry list. We'll take a look at all of the various torts within these intentional tort theories of liability, and we'll focus on defenses. By the way, intentional torts and defenses are worth maybe 6 or 7 questions out of the 34 questions on the MBE devoted to torts. So it's not the heart of the material in this topic, but it's important enough that we will focus our attention on it, and we'll do it first. We'll see this material echo when we get to criminal law, because criminal law is very similar to torts, except we've got a prosecutor instead of a civil plaintiff, and that prosecutor has a higher burden of proof than a civil plaintiff does in regular court. A prosecutor has to prove a case beyond a reasonable doubt, and typically a torts plaintiff only has to establish their claim by a preponderance of the evidence. Once we're done with intentional torts, we're going to turn our attention to negligence. Negligence is the single most important topic on any bar examination. And the reason I make that claim is because roughly 14 or 15 out of the 34 multi-state questions on torts come out of negligence. And that means negligence is the most heavily tested issue on the multi-state bar examination. And it is ready fodder for essay questioning also. Negligence is a complicated set of issues, but we will break it down remarkably quickly and efficiently. The basics of negligence are not that difficult, and the fine points are best obtained through practice rather than through abstract study. But you'll see as we get to the hypotheticals for this subject, I leave plenty of room to reconsider negligence as it is tested, and that will give you an idea about what areas within negligence you need to devote a little bit more attention to. After negligence comes strict liability and products liability. There are maybe 5 questions, maybe half a dozen MBE questions on this area of law, but it is very frequently tested on the essays all over the country, so we will look carefully at strict liability and products liability. We'll see it's fairly simple, and probably we'll be able to pick up a few points by knowing this material well. Next, we turn to all of the other torts, which include nuisance, defamation, the invasion of privacy torts, the business torts, and fraud. And this is where the law of contracts brushes up against the law of contracts. Remember, there's no punitive damages for breach of contract, the way there are punitive damages for intentional torts. So often, a civil litigant who is essentially bringing a contracts claim will also bring a torts claim for fraud, and the reason for doing that is a successful plaintiff who establishes a fraud cause of action is entitled to punitive damages, whereas one who establishes a claim for breach of contract or for negligence is not entitled to punitive damages. Next, we will focus on remedies, and remedies is, to my way of thinking, the most neglected subject on any bar examination. In fact, remedies is the heart of the bar exam. Remedies allows us to unlock torts, contracts, property, and often subjects like corporations or wills and trusts or professional responsibility. Remedies is what every plaintiff in civil court is looking for. And the sharper your understanding of remedies and how remedies relates to the various theories of liability and even to some of the defenses, is an invaluable body of knowledge. That's some stuff you want to know well, and not just for the bar examination. This is the heart of legal practice, too. So, once we are done going through all of the various theories of liability and defenses, a series of videos that will track the National Conference outline, then we will turn to the hypotheticals. There are 6 hypotheticals in this seminar, and I will encourage you to work your way through them. Don't just approach them passively. For each one of the hypotheticals, before you watch the video, go through it yourself. See if you can answer the questions presented. See if you can appreciate where you will find a home for the various facts. Now, the hypotheticals that I have chosen are presented in an essay format. But as you get into them, you'll see that the language in these questions, and to some extent even the question's length, will be very identifiable to you if you've done some multi-state practice already. These hypotheticals should be valuable both for the MBE and for the essays. Go through them the way you would go through an essay problem. See if you can outline them. See if you can issue spot them, and see if you can figure out what in your own mind a good answer would look like. Then watch the video. As you see me, what I'll be doing is reviewing the black letter law related to the question and also applying basic analytical tools that will be useful for you both on the multi-state and on the essays. Torts is an interesting subject. When you get to the next video, we'll be considering intentional torts.